So picture this. A company is right on the edge of financial collapse. It feels like there are just no good options left. But what if I told you there's a formal, legal way to basically hit the reset button? Without having to shut the whole thing down. Well, that's exactly what we're going to dig in today. It's this super powerful tool for business survival called a compromise with creditors. All right, let's imagine a scenario. You've got a business that's, fundamentally sound. It has a great product, awesome people, but the cash flow is just a total crisis. Debts are piling up, and then you start hearing that dreaded word, liquidation. Ugh, is that really the end of the road? Is it the only way out? Well, the answer, thankfully, is a big no. And this is that lifeline we're talking about. So what is a compromise? It's basically a formal agreement. The company and the people it owes money to, its creditors, they all come to the table, and they can agree to do things like cancel part of the debt, maybe even all of it, or just change the payment terms. And it's all for one big reason, to let the business survive and fight another day. Okay, so you might be wondering, how does a company actually do this? How do you get this process started? Well, the law actually gives you two very different ways to go. A good way to think about it is like choosing between a direct, face-to-face negotiation or calling in a powerful referee to help sort things out. Yeah, these two paths are pretty different. On one side, you've got what we'll call the direct deal. It's exactly what it sounds like, a straightforward agreement with creditors. And on the other side, there's the court's help, which is a much more formal, supervised process for when things get, well, messy. So let's dive into that first path, the direct deal.
All right, path one, the direct deal. Legally, this falls under something called a Part 15 compromise. Don't worry about the name, it's just named after its section in the Companies Act. The important thing to know is that this is the creditor-led, less formal option. It's really designed for those more straightforward debt situations where, hopefully, everyone can come to an agreement without needing a judge to step in.
And the process itself is actually pretty simple. It goes like this. First, someone formally proposes the deal. Step 2, all the creditors who are affected get a heads up about a meeting to talk it over. Step 3, and this is the big one, they vote. And finally, if it passes, that deal becomes legally binding on everyone who was notified. Yep, even the ones who voted no. Now, the most critical part of this whole thing, it really boils down to one single number, 75%. That's the magic number. For a direct deal to actually get approved, you need a 75% majority of creditors voting yes. It's a pretty high bar, and that's on purpose. It makes sure there's a really solid consensus before anything happens. So who actually gets to kick this whole process off? You might think it's just the company's directors, but it's not. A receiver can do it, a liquidator can do it, and here's where it gets really interesting. Even a single creditor or a shareholder can propose a compromise. Now, they do need the court's permission first, but the fact they can do it at all is huge. It gives lots of different people a chance to try and save the company. Okay, let's switch gears and talk about path 2, because, sometimes a simple debt deal just isn't going to cut it. When you're talking about massive changes like merging companies or untangling super complex financial webs, you really need the court's oversight. And that's where the Part 16 compromise comes in, again, just named for its spot in the Companies Act. So why bring the courts into it? Well, this path is for when a company's problems are way bigger than just simple debt. We are talking about major corporate surgery here. Things like company mergers or deep, complex reorganizations that the simple direct deal path just isn't built to handle. And let me tell you, when the court gets involved, it has immense power. This isn't just about rubber stamping a deal. The court can order meetings, it can demand independent reports, it approves the final plan, it can even order the transfer of assets, or if the whole rescue plan falls apart, order the company to be liquidated anyway. This is really serious, high-level stuff. So there we have it. We've looked at the two very different paths a company can take, the direct negotiation or the full-on court-supervised overhaul. Let's just put them side by side so the difference is absolutely crystal clear. Okay, think of this table as your ultimate cheat sheet. On one side, the direct deal, barely any court involvement, low complexity, and perfect for simple debt deals where the creditors are in the driver's seat. Then you've got the court's help path. It's the total opposite. High court involvement, way more complex, and it's built for those huge reorganizations where you need a judge to make sure everything is fair. Really, the key takeaway here is that it's all about choosing the right tool for the job. And all of this leaves us with a really fascinating final question to chew on. These processes, at their core, are all about a balancing act, right? It's the survival of a business versus the rights of the people it owes money to. So in that delicate dance, who do you think should really have the final say? Should it be the company that's fighting for its life? Or should it be the creditors who are just trying to get back what they're owed? It's a tough one, and that tension is right at the very heart of business law.